discrimination in the application must be proven. Lastly, a law might have a discriminatory impact combined with other evidence of purpose. While impact alone isn't enough, a law that is neutral on its face and in its application, but has a starkly disproportionate impact on a particular group, might trigger heightened scrutiny if there's other evidence suggesting a discriminatory purpose, like statements made during legislative debates, a suspicious pattern of actions, or if the impact is so extreme and inexplicable on neutral grounds that intent can be inferred. Think Yickwo or Gamillion. But just showing statistical disparity usually isn't enough for heightened scrutiny under Washington v. Davis.
Okay, so impact plus something else usually. Let's delve into these suspect classifications that trigger strict scrutiny. Race, ethnicity, and national origin are at the top of that list. How does this play out?
Indeed. For race, ethnicity, and national origin, any government classification based on these is inherently suspect and triggers strict scrutiny. In the context of school integration, the court has held that only de jure, intentional, legally mandated segregation in schools, violates the Equal Protection Clause, Brown v. Board. De facto segregation, which results from private choices like housing patterns rather than deliberate state action, generally does not trigger a constitutional remedy under the EPC.
And affirmative action, using race to benefit minorities.
Affirmative action programs that use racial or ethnic classifications to benefit minorities are also subject to strict scrutiny. To be upheld, they must be narrowly tailored to achieve a compelling government interest. The court has recognized remedying clearly proven past discrimination by the specific government actor using the program as potentially compelling. Achieving diversity in higher education has also been recognized as compelling in limited circumstances, but quotas are unconstitutional, and race can only be used as one plus factor among many in a holistic review. It's a very difficult standard to meet, and many affirmative action programs have been struck down or significantly limited.
What about classifications based on citizenship status or alienage? How does the scrutiny change depending on whether it's a federal or state classification? This seemed different.
For citizenship status, alienage, there's that crucial federal-state distinction. A federal classification based on citizenship status is generally subject only to rational basis review. This is because Congress has plenary power over immigration and naturalization, so federal laws treating citizens and non-citizens differently are often upheld.
Okay, federal gets deference. What about states?
In stark contrast, a state or local classification based on alienage is generally subject to strict scrutiny and will likely be struck down, because states don't have that same plenary power. However, there's a significant exception. State laws barring a non-citizen from participating in core government functions integral to the political community, like voting, serving on a jury, or working as a police officer or public school teacher, are subject only to rational basis review. The idea is that states can reserve these core self-governance roles for citizens. Also remember, states cannot deny undocumented children access to public primary or secondary education. Plyler v. Doe.
Got it. And for quasi-suspect classifications subject to intermediate scrutiny, we have gender and legitimacy. What's the standard there again?
For gender, classifications must be substantially related to an important government interest. There must also be discriminatory intent by the government to trigger intermediate scrutiny. Disparate impact alone is not enough. The government must show an exceedingly persuasive justification for the gender distinction, and classifications based on stereotypes are generally invalid. Separate facilities, if used, must be substantially equivalent. Affirmative action benefiting women might be permissible under intermediate scrutiny as a remedy for past societal or governmental gender-based discrimination. As for legitimacy, laws that discriminate against non-marital children are also subject to intermediate scrutiny. Legislation designed to punish non-marital children by denying them benefits or rights available to marital children will generally not be upheld.
So age, poverty, disability, sexual orientation fall into the non-suspect classifications, meaning the very deferential rational basis review applies to them under current law.
That's correct. Common non-suspect classifications include age, poverty, wealth, disability, though statutes often provide more protection, and sexual orientation. For these, the challenger must show the law is not rationally related to any legitimate government interest, which is very hard to do. It's important to note regarding sexual orientation, gender identity, that while the U.S. Supreme Court has ruled that Title VII of the Civil Rights Act of 1964 protects employees from discrimination based on these characteristics, this is statutory protection. Constitutionally, the court has not yet determined whether discrimination based on sexual orientation or gender identity is subject to heightened scrutiny under the Equal Protection Clause. So for now, it remains rational basis review constitutionally, although some argue it should be heightened.
Finally, are there any fundamental rights that are unique to equal protection and don't really overlap with substantive due process, perhaps in the context of political structure or participation?
Yes. While many fundamental rights, like the right to travel and the right to vote generally, are protected under both SDP and EP, there are a couple of rights specifically associated with the Equal Protection Clause in the context of political structure. First, one person, one vote. When the government establishes voting districts for the election of representatives, like Congress or state legislatures, the population of each district must be mathematically as equal as practicable. This ensures equal voting power among districts and applies to both state and federal elections for representatives.
Malapportionment claims.
Exactly. Second, gerrymandering based on race. Election districts for public office may not be drawn using race as the predominant factor in determining the boundary lines unless the district plan can survive strict scrutiny, which is almost impossible to meet. However, importantly, partisan gerrymandering claims, where districts are drawn intentionally to favor one political party over another, are considered non-justiciable political questions, meaning federal courts have declared they will not hear or decide these cases.
So courts won't fix partisan gerrymanders, only racial ones.
Under current doctrine, yes. A key bar exam tip here. The right to travel and the right to vote are frequently tested fundamental rights under both EP and SDP. The Equal Protection Clause tends to be the better fit if the question emphasizes denial of a right to a particular group based on a classification, while SDP might be more relevant if the denial seems more universal or burdens the right itself for everyone. 14. Privileges and Immunities Clauses.
Chapter 14 brings us to the Privileges and Immunities Clauses. Okay, these two clauses sound incredibly similar, but their application is actually quite distinct and definitely important to differentiate for the exam. What's the key starting point for understanding both of them? Who do they protect?
You've hit on a critical distinction right away. Both constitutional provisions, the one in Article 4 and the one in the 14th Amendment, use the term citizen, and it's crucial to remember that under both, the term citizen refers to natural persons who are U.S. citizens. It does not include corporations or aliens, non-citizens. So these clauses protect individual U.S. citizens from certain types of discrimination.
Okay, only citizens. Let's start with the Article 4 Privileges and Immunities Clause, sometimes called the Comity Clause. What's its core purpose, and what kind of rights does it protect for citizens visiting or moving to another state?
The Article 4 Privileges and Immunities Clause, or Comity Clause, primarily prohibits a state from intentionally discriminating against citizens of other states with respect to fundamental rights or essential economic activities. These rights include things like the right to pursue a common calling or profession, the right to own and transfer property, the right to access the state's courts, and generally the right to be treated the same as resident citizens regarding important commercial activities.
So states can't treat out-of-staters like second-class citizens when it comes to basic economic survival or legal access.
That's the core idea. It's about ensuring that non-residents aren't unfairly disadvantaged when it comes to basic rights necessary for earning a livelihood or participating in the nation's economic life. It fosters national unity and prevents state parochialism.
So, if a state does try to discriminate against out-of-state citizens under this clause, like charging much higher fees for commercial licenses, when, if ever, might that discrimination be valid? Is there any way for the state to justify it?
Discrimination against out-of-state citizens may be valid under Article 4, but only if the state can meet a demanding two-part test. First, the state must show a substantial reason for the difference in treatment. This usually requires demonstrating that non-residents pose a peculiar evil or unique problem that the state is legitimately trying to address, and that there's a substantial justification for targeting them specifically. Second, the discrimination must bear a substantial relationship to the state's objective. The discrimination must be closely related to solving the problem posed by non-residents, and there must not be less discriminatory alternatives available. It's a fairly rigorous test, tougher than rational basis, and often difficult for states to meet.
Okay. And does the market participant exception, which we discussed for the Dormant Commerce Clause, apply here to the Comity Clause? Can a state discriminate against out-of-staters if it's acting like a business? That's a common point of confusion.
That's another vital distinction for the bar exam. The market participant exception that applies to the Dormant Commerce Clause does not apply to the Article 4 Privileges and Immunities Clause. So, while a state acting as a market participant might be able to favor its own citizens under the DCC, for example, a state university charging lower tuition, or a state project hiring only state residents, it generally cannot do so under the Article 4 P&I clause if the discrimination infringes on fundamental rights like the right to pursue a livelihood. This difference often comes up in bar exam questions, so remember that nuance. In general, though, the P&I clause of Article 4 and the Dormant Commerce Clause often work together to invalidate state laws that discriminate against out-of-staters economically. Considering both is often a good strategy.
Got it. Market participant is a DCC exception, not P&I Article 4. Now let's turn to the 14th Amendment Privileges or Immunities Clause. Notice the or versus and. This one relates to national citizenship. This clause seems to be, well, less frequently litigated or successfully invoked historically. Why is that?
That's correct. The 14th Amendment Privileges or Immunities Clause was intended by its framers to be a major source of rights protection for citizens against state infringement. It protects citizens from state interference with the privileges or immunities of national citizenship. These rights include things like the right to interstate travel, the right to petition the federal government, the right to vote for national officers, the right to enter public lands, and the right to federal protection on the high seas or abroad.
That sounds potentially broad. Why isn't it used much?
Because very early on, in the slaughterhouse cases, 1873, the Supreme Court interpreted this clause incredibly narrowly, essentially limiting the privileges or immunities of national citizenship to just those rights that exist solely because of the relationship between the citizen and the federal government, not the fundamental rights that were thought to be included, like those in the Bill of Rights. As a result, this clause became largely redundant, as most rights of national citizenship were already protected elsewhere or are relatively minor. In modern practice, this clause is seldom successfully invoked and applies almost exclusively to challenges involving the fundamental right to travel interstate, which, as we've discussed, is also strongly protected under substantive due process and equal protection. So while historically important, it's rarely the winning argument today. XV Takings Clause, Chapter 15.
Chapter 15 focuses on the Takings Clause of the Fifth Amendment, applied to the states through the 14th. This is a fundamental property right question. When can the government take your private property, and what does it owe you if it does? It's a powerful check on the government's eminent domain power.
Absolutely. The Takings Clause provides that private property shall not be taken for public use without just compensation. It serves as a critical check on the government's inherent power of eminent domain, the power to take private property for public purposes like roads or parks. The first step in any Takings Clause analysis is always to identify if the claimant actually has a recognized property interest that's being affected.
What kind of property interests are actually protected under this clause? Is it just land, real estate?
No, the protection extends quite broadly to various forms of recognized property interests, not just physical land. Real property is included, of course, fee simple ownership, easements, liens, leaseholds, even mineral rights sometimes. It also covers tangible personal property, think cars, equipment, etc. And importantly, it can even cover intangible property like trade secrets, contract rights, patent rights, and sometimes even the interest accruing on certain funds. The key is a recognized legal interest in something specific.
Okay, and what are the different ways a taking can actually occur? It's not just the government literally planting a flag on your land and saying mine.
No, it's definitely more complex than that. There are several ways a taking can occur under the Fifth Amendment. The classic application is a physical taking or physical seizure. This involves an actual physical appropriation or occupation of property by the government, or a direct governmental invasion onto the land. This is the clearest type of taking. This can also arise from government action that causes permanent physical damage to or destruction of property. The primary challenge here is usually whether the owner received just compensation.
So physical occupation or destruction. What else?
Then there's what might be called recharacterization, though it's less common. This is where the government effectively recharacterizes private property as public property, perhaps by declaring private wetlands a public preserve accessible to all, without providing compensation to the owner. It's like a physical taking, in effect. More common, though, are regulatory takings.
The tricky ones. If a zoning law significantly reduces my property value, is that automatically a taking?
Generally, no. A government regulation that merely adversely affects a person's property interest or reduces its value is usually not a taking. Zoning laws, building codes, environmental regulations, These are typically upheld as legitimate exercises of the state's police power, even if they diminish property value as long as they don't go too far.
Hmm.
Property owners don't have a right to the most profitable use of their land.
Okay, so when does a regulation become a taking? When does it go too far?
A regulation does constitute a taking, sometimes called a per se regulatory taking, in two specific, fairly extreme scenarios identified by the court. First, when the regulation results in a permanent physical occupation of the property by the government or a third party authorized by the government, no matter how small the occupation. Think of the Loretto case, requiring landlords to allow cable TV boxes on their buildings. Even that small physical intrusion was deemed a taking. Second, a regulatory taking occurs if the regulation results in a permanent total loss of the property's economically beneficial or productive use. If the regulation leaves the owner with literally no viable economic use of the land, like a ban on all development that renders coastal land completely valueless, Lucas case, it's considered a taking requiring compensation, unless the restriction mirrors background principles of state property or nuisance law that already existed.
Total economic wipeout. Okay, and what's an exaction? This term comes up quite a bit in development and land use cases. It sounds like the government demanding something in exchange for permission.
That's exactly what it is. An exaction occurs when a government demands that a developer dedicate part of their land for public use, like a park or road widening, or pay a fee, an impact fee, as a condition for obtaining a building permit or development approval. For example, requiring a developer to build sidewalks or contribute to a school fund in exchange for permission to build a new housing development.
Are those always allowed?
Not always. Exacting such promises or property from a developer does not violate the takings clause only if two conditions are met, under the Nolan and Dolan cases. First, there must be an essential nexus between the exaction demanded and the legitimate state interest the government is trying to further with the permit condition. The condition has to relate to the purpose of the regulation. Second, there must be rough proportionality between the burden imposed on the property owner by the exaction and the projected impact of the proposed development. The burden or cost imposed can't be wildly out of proportion to the problem or impact the development itself is expected to create.
Nexus and rough proportionality. Got it. So, if a taking does occur through any of these means, physical, regulatory wipeout, or invalid exaction, what exactly is the just compensation the government must provide to the owner?
When a taking occurs, the government must provide just compensation, which the Supreme Court has defined as the fair market value of the property at the time of the taking. This is generally measured objectively what a willing buyer would pay a willing seller on the open market for that property interest. It's measured in terms of the loss to the owner, not based on any subjective value to the owner or the potential benefit the government gains from acquiring the property. Fair market value is the standard. Prohibited legislation, Chapter 16.
Chapter 16 is about specific types of prohibited legislation. These are certain kinds of laws that are absolutely forbidden by the Constitution, regardless of the government's purpose, because they fundamentally undermine core principles of justice, fairness, and the separation of powers. They're like constitutional bright-line rules against certain legislative actions.
That's correct. These are categorical prohibitions on legislative power designed to prevent specific historical abuses. First, we have bills of attainder. Both the federal government, Article 1, Section 9, and state governments, Article 1, Section 10, are prohibited from passing bills of attainder.
What exactly is a bill of attainder?
A bill of attainder is an unconstitutional legislative act that singles out an identifiable individual or group, determines their guilt for some past action, and imposes punishment, like barring them from employment, confiscating property, or even imprisonment, without the benefit of a judicial trial. It's essentially the legislature acting as judge, jury, and executioner, which directly violates the principles of due process and separation of powers.
Okay, legislature can't punish specific people without a trial. What about ex post facto laws? That sounds like retroactively punishing someone for something that wasn't illegal when they did it.
Precisely. Ex post facto laws are also prohibited for both Congress and the states by Article 1, Sections 9 and 10. An ex post facto law is unconstitutional specifically if it does any of the following four things retroactively to a defendant's disadvantage in a criminal case. 1. It criminalizes an act that was perfectly legal when it was committed. 2. It increases the punishment for a crime after the crime was committed. 3. It deprives a defendant of a legal defense that was available when the act was committed. Or 4, it decreases the prosecution's burden of proof required for conviction below what was required when the act was committed.
So it only applies to criminal laws and only if it disadvantages the defendant.
Correct. The ex post facto clause applies only to criminal laws, not civil ones, and only if the retroactive change is detrimental to the criminal defendant. It prevents the government from unfairly changing the rules of the game after the fact to make it easier to convict or to impose harsher penalties for past conduct.
Makes sense. Finally, the obligation of contracts, or the contracts clause. How does that protect existing contractual agreements from governmental interference?
The Contracts Clause, found in Article 1, Section 10, states that no state shall pass any law impairing the obligation of contracts. Notice this prohibition applies only to state legislation, not to federal legislation, though the federal government might be limited by due process.
Only states impairing contracts.
Right. And critically, it applies only to state laws that retroactively impair existing contractual rights. It does not apply prospectively to future contracts. The purpose is to protect the stability and reliability of existing contractual agreements from state interference, ensuring that individuals and businesses can rely on the deals they've made.
Is it an absolute ban? Can states never modify existing contracts?
It's not absolute. While the clause seems strict, the Supreme Court has interpreted it somewhat flexibly, especially regarding private contracts. States can interfere with existing private contracts if the state law serves a significant and legitimate public purpose, like addressing a major economic emergency, and the impairment is reasonable and narrowly tailored to achieve that purpose. Interference with public contracts the state itself is party to, faces a higher level of scrutiny, making it harder for the state to modify its own obligations. But it's not an absolute bar, especially for private contracts facing legitimate police power regulation. Freedom of religion, Chapter 7.
Chapter 17 brings us to the First Amendment's dual protection for religion, preventing government establishment of religion and protecting individuals' free exercise of religion. These two clauses, the Establishment Clause and the Free Exercise Clause, sometimes seem to pull in opposite directions, creating a really delicate balance.
They absolutely do, and understanding their distinct roles and how they interact, sometimes complementing, sometimes conflicting, is key. Let's start with the Establishment Clause. Broadly, it prohibits the government from establishing an official religion, endorsing religion over non-religion, or preferring one religion over another.
Separation of church and state, basically.
That's the common shorthand, yes. When a governmental program or action shows a clear preference for one religion over another, or for religion in general over non-religion, strict scrutiny applies. This means the government must have a compelling interest and use the least restrictive means, a very high bar. However, the court's modern approach, especially in cases involving historical practices, also considers the country's historical practices and understandings about the role of religion in public life.
So history matters now.
History and tradition seem to matter quite a bit now. This is why things like "In God We Trust" on currency or non-coercive legislative prayer are generally permissible. They are seen as reflecting historical tradition rather than establishing religion. The old Lemon Test, secular purpose, primary effect neither advances nor inhibits religion, no excessive entanglement, is still sometimes referenced, but its status is unclear, and the historical approach seems more dominant currently.
Okay. What about financial aid to religiously affiliated institutions, like schools or hospitals? When is that permitted, given the separation idea?
Financial aid to religiously affiliated institutions is a complex area. Generally, aid is permitted if it meets certain criteria, ensuring neutrality. The aid should be secular in nature, used only for secular purposes, can't be diverted to religious instruction or worship, and distributed according to religiously neutral criteria, meaning it's available to all similar institutions, religious or not, based on objective standards.
So providing secular textbooks or computers is okay.
Yes. Providing secular textbooks, computers, transportation, standardized testing services, or even sign language interpreters for deaf students has generally been upheld. Tuition vouchers are also generally valid if parents have a genuine private choice among both religious and non-religious schools, as the aid flows through the parent's choice, not directly from the state to the religious school. However, states generally cannot provide funds directly for religious instruction or to students specifically pursuing a devotional religious career.
And in public schools themselves, what types of religious activities are generally prohibited versus permitted? This is always a flashpoint.
In public schools, the court has been fairly strict about preventing government endorsement of religion. Invalid activities under the Establishment Clause typically include organized, school-sponsored prayer, even supposedly voluntary or non-denominational prayer led by school officials, devotional Bible reading initiated by the school, periods of silence specifically for meditation or voluntary prayer, if lacking a clear secular purpose, prayer at school events like graduations or football games that are sponsored or led by the school, posting the Ten Commandments on classroom walls as a religious document, and prohibiting the teaching of evolution because it conflicts with religious beliefs.
Okay, so school-sponsored religious exercises are generally out. What's allowed?
Valid activities generally include genuinely voluntary private prayer by students that isn't disruptive, teaching about religion or the Bible in a secular context, like history or a literature class, student-led religious clubs having equal access to facilities as other non-curricular clubs under the Equal Access Act, and perhaps even a coach participating in private prayer with students if it's genuinely student-initiated and not coercive. The line is often about endorsement and coercion by the school itself.
What about access to school facilities by outside religious groups? If secular community groups can use the gym after hours, can religious groups too?
Yes. If a public school creates a limited public forum by allowing outside community groups or